Jai Hind everyone. Welcome to my YouTube channel, which is Explore Yourself, Banking and General Knowledge, etc. Please subscribe to the channel and also please do like and share and leave your suggestions in the comment section. Today I am going to share the details of policy on operational procedure for settlement of claims in deceased or missing depositors accounts. Introduction. Death of a person is a turbulent period, both mentally and financially, for the members of the bereaved family. Speedy disposal of claim petitions of deceased depositors would be a relief to the legal heirs or nominee or survivors of the deceased depositors. Claims by nominees or heirs could be in respect of deposits, safe custody articles, or contents of lockers. Objective of this policy is to provide better customer service by avoiding hardships to the nominees or heirs of the depositors and to settle their claims as expeditiously as possible. With a view to eliminate the hardships faced by the common person, RBI Committee on Procedures and Performance Audit on Public Services (CPPAPS) had suggested that Reserve Bank of India may issue comprehensive guidelines in the matter, and IBA may be asked to draft and circulate a comprehensive model operational procedure, which could be adopted by banks for settlement of claims of deceased depositors and SDB lockers or safe custody articles. The legal position is quite clear in the matter of deceased claims. In the absence of nomination or clear mandate in respect of a joint account or a will left behind by the deceased depositor, banks are expected to pay the stock balances to all the legal heirs of the deceased. Considering the risks involved, banks traditionally used to insist for legal representations in the form of succession certificate, letter of administration, or probate, etc. For settlement of claims, the system of obtaining operational mandates in joint accounts emerged as a banking practice to overcome difficulties in settlement of claims in deceased accounts. Subsequently, the statutes were amended in 1985 to provide for nomination facility in bank deposits, safe deposit lockers, and safe custody articles. However, since nomination facility is optional at the discretion of the depositor or lessee, problems and difficulties in settlement of deceased claims persists. Guidance to the customers on advantages of nomination facility or survivorship mandate. Nomination. Nomination facility. An ideal tool to mitigate hardships of common persons in settlement of claims in the event of death of the account holder. Nomination facility simplifies the procedure for settlement of claims of deceased depositors as banks get valid discharge by making payment of the balances in the depositor's account at the time of depositor's death or delivery of contents of locker or articles kept in safe custody to the nominee. Nomination is optional for bank customers. It is therefore necessary that nomination facility is popularized and customers are made aware of advantages of nomination at the time of opening a deposit account or opting for the SDB lockers or safe custody. Branches should inform account holder about the availability of nomination as a voluntary facility and recommend to availing the option. Nomination facility, if availed, would ensure a smooth settlement of claim to the nominee. It should also be made clear to the depositors that nomination is introduced solely for the purpose of simplifying the procedure for settlement of claims in the event of demise of depositors, and nomination facility does not take away the rights of legal heirs on the estate of the deceased. The nominee would be receiving the stock from the bank as a trustee of the legal heirs. Survivorship. A joint account opened as either a survivor or anyone or survivors or former or survivor or later or survivor will permit the surviving account holders to have unimpeded access to the credit balance in the account for withdrawal if one of the co-account holders dies. If the mandate of survivorship is given or provided, the survivors can give a valid discharge to the bank in the case of either a survivor, anyone or survivors, and former or survivor or later or survivor joint accounts. In short, payment to survivors can be made in the normal course subject to the rider that there is no order from a competent court restraining the bank from making such payment. Settlement of claims in various types of accounts or facilities. Single account with or without nomination. Saving account or current account with nomination. The balance amount will be paid to the nominee on verification of nominee's identity and proof of death of depositor. Without nomination, the balance amount will be paid to the legal heirs or any one of them as mandated by all the legal heirs on verification of the authority of the legal heirs and proof of death of depositor. Term deposit account payment on maturity with nomination. The balance amount will be paid to the nominee on verification of nominee's identity and proof of death of depositor on maturity of deposit. Without nomination, the balance amount will be paid to the legal heirs or any one of them as mandated by all of the legal heirs on verification of the authority of legal heirs and proof of death of depositor on maturity of deposit. Term deposit account premature termination with nomination. Premature termination of term deposit account as per terms of contract will be permitted at the request of the nominee on verification of nominee's identity and proof of death of depositor. Without nomination, premature termination will be permitted on joint request by all legal heirs or any of them as mandated by all the legal heirs as per the terms of the contract on verification of the authority of the legal heirs and proof of death of depositor. Joint account with or without nomination and without survivorship mandate operated jointly. Saving account and current account with nomination. In the event of death of one or more but not all of the joint account holders, the balance amount will be paid jointly to the survivors and the legal heirs of the deceased joint account holder or any one of them as mandated by all the legal heirs against their joint claim on verification of the authority of the legal heirs and proof of the death of the depositors. With nomination. In the event of death of both or joint account holders, the balance amount at the time of death of the depositors will be paid to the nominee on verification of nominee's identity and proof of death of all depositors. Without nomination. In the event of death of one or more but not all of the joint account holders, the balance amount will be paid jointly to survivors and the legal heirs of the deceased account holder or any one of them as mandated by all the legal heirs against their joint claim on verification of the authority of legal heirs and proof of death of depositor. Without nomination. In the event of death of both or all joint account holders, the balance amount will be paid jointly to the legal heirs of all the deceased depositors or any of them as mandated by all the legal heirs on verification of authority of the legal heirs and proof of death of all the depositors. Joint account with or without nomination and without survivorship mandated operated jointly. Term deposit account, payment on maturity. With nomination. In the event of death of one or more but not all of the joint account holders, the balance amount will be paid jointly to survivors and the legal heirs of the deceased joint account holder or any one of them as mandated by all the legal heirs on verification of identity of the legal heirs and proof of death of the depositor on maturity of the deposit. In the event of death of both or all the joint account holders, the balance amount at the time of death of the depositors will be paid to the nominee on verification of nominee's identity and the proof of death of all depositors on maturity of the deposit. Without nomination. In the event of death of one or more but not all of the joint account holders, the balance amount will be paid jointly to the survivors and the legal heirs of the deceased joint account holders or any of them as mandated by all the legal heirs against their joint claim on verification of authority of the legal heirs and proof of death of the depositors on maturity of the deposit. In the event of death of both or all the joint account holders, the balance amount will be paid jointly to the legal heirs of all the deceased depositors, any one of them as mandated by all legal heirs on verification of authority of the legal heirs and proof of death of all depositors on the maturity of the deposit. Joint account with or without nomination and without survivorship mandate operated jointly. Term deposit account premature termination. With nomination. In the event of death of one or more but not all of the joint account holders, premature termination of term deposit will be permitted against joint request of the survivors and the legal heirs or any one of them as mandated by all legal heirs as per the terms of contract on verification of identity of the legal heirs and proof of death of depositor. Premature termination of term deposit account as per the terms of contract will be permitted at the request of the nominee on verification of nominee's identity and proof of death of all the depositors. Without nomination. In the event of death of one or more but not all of the joint account holders, premature termination of term deposit will be permitted against joint request by the survivors and the legal heirs of all the deceased depositors or any one of them as mandated by all legal heirs as per the terms of contract on verification of authority of legal heirs and proof of death of depositor. In the event of death of both or all the joint account holders, premature termination of term deposit will be permitted against joint request by all legal heirs of the deceased depositors or any one of them as mandated by all legal heirs as per the terms of contract on verification of authority of legal heirs and proof of death of depositors. Joint account with mandate either survivor, former or survivor, anyone or survivors, later or survivor, with or without nomination. Saving account and current account. With nomination. In the event of death of one or more but not all of the depositors, the balance amount will be paid to survivors on verification of proof of death of the depositors. In the event of death of both or all the joint depositors, the balance amount will be paid to the nominee on verification of nominee's identity and proof of death of all depositors. Without nomination. In the event of death of one or more but not all of the depositors, the balance amount will be paid to survivor on verification of proof of death of the depositors. In the event of death of both or all the joint depositors, the balance amount will be paid jointly to the legal heirs or any one of them as mandated by all the legal heirs on verification of authority of legal heirs and proof of death of all the depositors. Joint account with mandate either or survivor, former or survivor, anyone or survivors, later or survivor, with or without nomination. Term deposit account, payment on maturity, with nomination. In the event of death of one or more but not all of the depositors, the balance amount will be paid to survivors on verification of proof of death of the depositors on maturity of deposit or as agreed at the time of opening of deposit. In the event of death of all joint depositors, the balance amount will be paid to the nominee on verification of nominee's identity and proof of death of all depositors on maturity of deposit or as agreed at the time of opening of deposit. Without nomination. In the event of death of one of the depositors or more, but not all, the balance amount will be paid to the survivors on verification of proof of death of the depositors on maturity of deposit or as agreed at the time of opening of deposit. In the event of death of all joint depositors, the balance amount will be paid to the legal heirs of all the deceased depositors or any one of them as mandated by all the legal heirs of joint holders on verification of authority of legal heirs and proof of death of all depositors on maturity of deposit. Joint account with mandate either or survivor, former or survivors, anyone or survivors, later or survivor, with or without nomination. Term deposit account, premature termination, with nomination. In the event of death of all the joint depositors, the nominee will have right to seek premature termination of term deposit account as per the terms of the contract on verification of claimants and proof of death of all depositors. Without nomination. In the event of the death of one or more, but not all, of the depositors, the balance amount will be paid to the survivors after premature termination of term deposit account on verification of proof of death of the depositors only if there is a joint mandate from all the depositors to this effect given either at the time of placing the fixed deposit or subsequently during the tenure of deposit or there is suitable clause in this regard in deposit account opening forms which is accepted and signed by all the depositors at the time of opening of fixed deposit account without nomination. In the event of the death of one or more but not all of the depositors, the balance amount will be paid jointly to survivors and the legal heirs of the deceased joint account holder or any one of them as mandated by all the legal heirs against their joint claim on verification of authority of the legal heirs and proof of death of depositors if there is no joint mandate from all the depositors or suitable clause in account opening form to this effect as stated in clause 1 above. Settlement of claims in various types of accounts facilities. HUF accounts, death of Karta. In the event of death of a Karta, HUF account may be settled as under obtaining affidavit cum indemnity from surviving members and legal heirs with two sureties confirming their acceptance to one of the members as a new Karta. Banks shall allow the new Karta to continue to operate the existing account on the basis of such documents in HUF accounts having balances up to rupees 1 lakh. Similar procedure to be followed in cases where account is to be closed and balance in the account to be paid to the new Karta. Simplification of the process for settlement of claims in deceased depositors accounts with nomination facility or survivor clause. Following documents required to be submitted by nominees or survivors to branches for settlement of claims in deceased depositors' accounts. Claim form. Bank will provide the form. Proof of death of depositor issued by the appropriate authority. Proof of identification of nominees or survivors. Stamped receipt for amount received signed by nominee or survivors or person on behalf of minor nominee. Bank will provide the form. Without nomination facility or survivor clause. Following document required to be submitted by legal heirs to branches for settlement of claims in deceased depositors' accounts. On production of legal representation or court order. Claim form. Bank will provide the form. Proof of death of depositor issued by appropriate authority. The legal representation grant should be produced in original, usually, or true certified copy obtained from the court. The identity of holders of grant of legal representation should be proved to be satisfaction of the bank officials. Stamped receipt for amount received signed by claimants, persons on behalf of minor claimants. Bank will provide the form. In the absence of legal representation or court order, in cases where the deceased depositor had not made any nomination or for the joint accounts without survivorship clause, such as single or jointly operated accounts, banks have been advised to adopt a simplified procedure for repayment to legal heirs of the depositor, keeping in view the imperative need to avoid inconvenience and undue hardship to the common person. Banks have also been given discretion keeping in view their risk management systems to fix a minimum threshold limit for the balance in the account of the deceased depositors, up to which claims in respect of the deceased depositors would be settled without insisting on production of legal representation. Accordingly, after due deliberations and looking into the uniform, lenient and simplified documentation advised by Indian Banks Association (IBA) via the letter number CII is BCC dated 22nd August 2019 under the roadmap of Department of Financial Services (DFS) for banking reforms of EASE 2.0 Banking for Customer Convenience. It has been decided not to insist for legal representation by way of succession certificate or letter of administration, probate, etc., where the amount involved is up to rupees 40 lakhs, in which cases the claim can be settled in favor of legal heirs by obtaining declaration, letter of indemnity, affidavit, opinion, report of sureties, and other documents such stated under after obtaining approval of the competent authority as per the delegation of powers. However, where there is dispute between the legal heirs or claimants, even if the claim is within the threshold limit of rupees 40 lakhs, branches should insist for necessary court order by way of succession certificate or letter of administration. Claim form, bank will provide the form. Proof of death of depositor issued by appropriate authority. Proof of authority of legal heirs wherever applicable. Letter of disclaimer duly stamped and notarized wherever applicable. Bank will provide the form. Proof of identification of legal heirs wherever applicable. Affidavit stating that the deceased died intestate and there are no other legal heirs other than the one mentioned therein to be stamped as per local law. Affidavit to be executed before a notary or magistrate or other officer authorized by state government wherever applicable. Bank will provide the form. Letter of indemnity signed by all legal heirs and two sureties acceptable to the bank wherever applicable. Bank will provide the form. Opinion report of sureties wherever applicable. Bank will provide the form. Stamped receipt for amount received signed by claimants or person on behalf of minor claimants. Bank will provide the form. If claim amount in deceased depositors accounts balance up to and inclusive of rupees 5,000 including up to date interest Requirement Details of requirement of indemnity, affidavit of securities, and net worth of securities. Declaration from respectable persons well known to the deceased family as in claim form. Declaration or undertaking from claimants as in claim form. Unstamped letter of indemnity signed by all the heirs. Claim amount in deceased depositors accounts above rupees 5,000 and up to and inclusive of rupees 25,000 including up to date interest. Details on requirement of indemnity, affidavit and securities and net worth of securities as declaration from respectable persons well known to deceased family as in claim form. Declaration or undertaking from a claimant as in claim form. Affidavit duly stamped and notarized as in claim form. Stamped letter of indemnity signed by all the heirs. On security or more security jointly of good standing for the amount involved. Claim amount in deceased depositors accounts above rupees 25,000 and up to and inclusive of rupees 5 lakhs including up to date interest. Details on requirement of indemnity, affidavit and securities and net worth of securities. Stamped letter of indemnity signed by all the heirs. One security or more securities jointly of good standing for twice the amount involved. Claim amount on deceased depositors accounts above rupees 5 lakhs and up to and inclusive of rupees 40 lakhs including up to date interest. Details on requirement of indemnity, affidavit and securities and net worth of securities as stamped letter of indemnity signed by all the heirs. One security or more securities jointly of good standing for thrice the amount involved. Wherever the claimants are finding it difficult and not able to obtain legal heir certificate, branches may settle the claim without insisting for legal heir certificate up to rupees 5,000 on basis of declaration undertaking from claimants. Bank will provide the form and declaration from respectable persons well known to deceased family as in claim form and claim above rupees 5,000 and up to and inclusive of rupees 25,000 including up to date interest with an additional documents that is affidavit duly stamped and notarized subject to condition that the sanctioning authority is fully satisfied about the integrity and bona fides of the claimants after due inquiry. Due diligence. Following due diligence to be undertaken by branches at the time of settlement of claims. Proof of identification of nominees or survivors or legal heirs should be ensured by obtaining photocopy of any OBDs verified with original OBDs, that is passport, driving license, proof of possession of Aadhaar number, the voter's identity card issued by the Election Commission of India, a job card issued by NREJ duly signed by an officer of the state government, letter issued by the National Population Register containing details of name and address or any other satisfactory proof of identification acceptable to the bank. Branches should ensure that name appearing in death certificate tallies with account opening form. In case of nomination, verify the name of the nominee in nomination form and in the account. Procedure for prescribed for closing accounts such as surrender of original passbooks, unused check leaves, production of deposits receipts duly discharged by nominee or claimants, etc. to be followed. Satisfy that legal representation is issued by the competent court and legal representation produced by the claimants should relate to the accounts of the deceased wherever applicable. Particulars of the amount payable by the bank to the deceased are correctly mentioned or shown in the legal representation, succession certificate or probate, letter of administration, etc. on the strength of which payment is desired to be made to the claimants wherever applicable. Branches should ensure that payment should be made through account pay only, pay order, demand draft, or as per the terms of the court order wherever settlement done on the basis of legal representation after getting receipt. Branches must exercise due care and caution in ascertaining the identity of legal heirs, nominees, and proof of death of the account holder through appropriate documentary evidence, if necessary. Any official of the branch shall visit the place of the depositors to inquire about the genuineness of such claims. Bank will provide the form. In cases where settlement will be made to the survivors, nominee as per the terms of the contract, it should be made clear to the survivors or nominee that he or she or they would be receiving the payment from the bank as trustee of the legal heirs of the deceased depositor. That is, such payment to him or her or them shall not affect the right or claim which any person may have against the survivors or nominees to whom the payment is made. It may be noted that payment made to the survivors in cases where there is a mandate to the effect like either a survivor or former survivor or nominees subject to the foregoing conditions would constitute full discharge of the bank's liability. Insistence on production of legal representation is superfluous and unwarranted, and it would only serve to cause avoidable inconvenience to the survivors or nominees. In such cases, making payment to the survivors or nominees of the deceased depositor, branches should not insist on production of succession certificate, letter of administration or probate, etc., or obtain any bond of indemnity or surety from the survivors or nominees, irrespective of the amount standing to the credit of the deceased account holder. In the absence of nomination and when there are no disputes among the claimants, the bank will pay the account balance amount of the deceased account holders against joint application and indemnity by all the legal heirs, all or the authorized representative mandated by all the legal heirs to receive the payment on their behalf without insisting on legal documents up to the limit of rupees 40 lakhs approved by the bank's board. This is to ensure that the depositors are not put to undue hardship on account of delays in completing legal formalities. Branches may keep the claim amount in form of saving account or FDR in the name of minor represented by natural guardian till attaining the majority, else a declaration for utilizing of the claim amount for the exclusive benefit of the minor should be obtained from the natural guardian if the dues balance in missing person or depositor's account are settled in favor of minor. Time norms for settlement of claims. Branches should settle the claims in respect of deceased depositors and release payment to survivors or nominee in accounts with survivor or nominee within a period not exceeding 15 days from the date of receipt of the claim, subject to production of documentary proof of death of the depositors and suitable identification of the claimants to the bank's satisfaction. In case of accounts without survivor or nominee clause, the claim should be settled within 1 month from the date on which the requisite documents have been submitted. The claim should be settled following the procedure in vogue and on approval of the competent authority as per the delegation of powers. Payment of interest in case of term deposit accounts of deceased depositors. In case of a term deposit standing in the names of a deceased individual depositor or two or more joint depositors where one or all the depositors have expired, interest shall be paid in the manner indicated below. On the maturity of the deposit, bank will pay interest at the contracted rate till the date of maturity of deposit. In case of premature withdrawal by legal heirs or nominee or legal heir, that is in the event of the payment of deposit being claimed before the maturity date or contract period, the bank will pay applicable rate of interest on the date of acceptance of deposit for the actual period for which deposit has remained with the bank or contracted rate of interest, whichever is lower, shall be applicable without charging penalty. In case of deposit being claimed after the date of maturity, A. In the case of death of depositors after the date of maturity of the overdue deposit, the bank shall pay interest at saving bank rate applicable as on the date of maturity up to the date of payment. In the event of death of the depositor, before the date of maturity of deposit and where the amount of the deposit is claimed after the date of maturity, the bank shall pay interest at the contracted rate till the date of maturity, and thereafter that simple term deposit interest applicable as on the date of maturity for the period for which the deposit remained with the bank beyond the date of maturity. In the event of auto-renewal system of term deposits for the same tenure as of maturing deposit at the then prevailing rate of interest applicable as on date of maturity, bank shall pay interest at the contracted rate or prevailing rate up to the date of maturity span of such auto-renewal period during which depositor has expired, and thereafter simple term deposit interest at applicable rate for the period as in the date of renewal or maturity up to the date of payment. Splitting of term deposit. On a specific request from the claimants, branches may split the amount of term deposit and issue two or more separate receipts in the names of the claimants. This shall not be constituted as premature withdrawal of the term deposit, provided the period and the aggregate amount of the deposit do not undergo any change. Treatment of flow in the name of the deceased depositor. In order to avoid hardship and inconvenience to the survivors or nominee of a deceased deposit holder, account holder, branches will obtain appropriate agreement or authorization from the survivors or nominee with regard to the treatment of pipeline flow in the name of the deceased account holder. In this regard, branches should consider adopting either of the following approaches. The survivors or nominee of a deceased account holder should authorize the branch to open an account styled as state of Sri or Ms. The deceased where all the pipeline flow in the name of the deceased account holder could be allowed to be credited, provided no withdrawals are made. Or the survivors or nominee should authorize the branch to return the pipeline flow to the remitter with the remark, account holder deceased under intimation to survivors or nominee. The survivors or nominee or legal heirs can then approach the remitter to effect payment through a negotiable instrument or through electronic transfer of amount in the name of the appropriate beneficiary. Provision of law regarding legal heirs. Hindu. If the deceased is a male dying intestate, it must be ascertained whether there are one or more class 1 legal heirs. The following are class 1 legal heirs: mother, widow, sons, daughters, widow of predeceased son, sons and daughters of a predeceased son, sons and daughters of a predeceased daughter, sons and daughters and widow of a predeceased son of a predeceased son, sons and daughters of predeceased daughter of predeceased daughter, daughters of predeceased son of a predeceased daughter, daughters of predeceased daughter of predeceased son. All class 1 legal heirs take simultaneously to the exclusion or any other legal heir, and no one takes precedence over the other. The class 2 legal heirs are classified in different entries, and legal heirs belonging to entry 1 will be referred to the second entry and so on in succession. However, there is no preference among these falling in the same entry and they take their share simultaneously. Entry 1 Father. All class 1 legal heirs take simultaneously to the exclusion of any other legal heir and no one takes precedence over the other. The class 2 legal heirs are classified in different entries and legal heirs belonging to entry 1 will be preferred to the second entry and so on in succession. However, there is no preference among those falling in the same entry and they take their share simultaneously. Entry 1 Father. Entry 2 Sons, daughters, son. Sons, daughters, daughter. Daughters, daughter's son. Daughters, daughter's daughter. Brother and sister. Entry 3 son or daughter of daughter's son, and son or daughter of daughter's daughter. Entry 4. Give son or daughters of brother or sister as the heirs and many more. In case the deceased is a married female Hindu who died intestate, the following are her legal heirs: sons and daughters, including the children of any predeceased son, and the husband, heirs of husband, mother and father, heirs of father, heirs of mother. If a female Hindu who dies intestate does not have son or daughter, the property inherited from her parents goes to the heirs of father, whereas if the same is inherited from husband or parents-in-law, heirs of husband will be the claimants to inherit property. Provision of law regarding legal heirs. Christian. Where the deceased is a Christian, Indian Succession Act governs the intestate succession. As per the provision of Succession Act, the widow of the male intestate is entitled to one third of the property, while the remaining two thirds goes to lineal descendants, that is, sons and daughters in equal shares. If the male intestate has left no lineal descendant but has left persons who are kindred to him, then one half goes to the widow and other half to the kindred, that is, father, mother, brother, or sister. If the deceased has left none who are kindred to him, the whole property passes to his widow. In case a Christian female dies intestate, husband has the same right. Provision of law regarding legal heirs. Mohammedan. Inheritance in the case of Muslims is governed by the Sunni or Shia law, depending upon the sect to which they belong. According to Sunni law, the class of heirs are sharers, ascendants, heirs by consanguinity, father, true grandfather, mother, true grandmother, descendants, daughter, son's daughter, collateral, full or consanguine sister, uterine brother or sister, heirs by affinity, husband or wife. These 12 sharers will inherit or fixed shares subject to conditions. A sharer may be excluded by many reasons, such as nearer to blood will exclude remote one in one class. Sometimes sharer may be converted as residuary, or otherwise one sharer may be partly sharer and partly residuary. Mohammedan residuary category. After fixed share is allotted to the sharers, the residue left is devolving upon the residuary. Children, male or female, of deceased, of son of deceased, of father of deceased, male descendants of true grandfather. Son is always a residuary. Daughter with son becomes residuary. Among these, descendants exclude all others. Ascendants exclude all others, except descendants and descendants of nearer. Ascendants exclude those in remote. Each class of residuary nearer blood excludes remote one. Division among these is according to the rule of double share to the male, and if only one sex is there, then equally divided. In the absence of sharers and residuary estate devolves upon his other blood relations, that is distant kindred. Provision of law regarding legal heirs. Mohammedan. According to Shia law, the class of heirs are heirs by consanguinity: 1a parents, 1b children and descendants, 2a grandparents, true or false, 2b brother or sister and descendants, 3 paternal or maternal uncle of him or his parents and grandparents. Provision of law regarding legal heirs. Mohammedan. According to Shia law, the class of heirs are heirs by marriage, husband or wife, heirs by consanguinity, and heirs by affinity succeed simultaneously. Among heirs by consanguinity, those in class 1 exclude those in class 2. The heirs in two sections of class 1 succeeds together in each section, nearer in degrees exclude the remote. The son always takes as a residuary. Signed certificate from Muslim Jama'at on the letterhead by the head of the institution to which the deceased was affiliated should be obtained, giving details of legal heirs with their age. In case of deceased male, a categorical certificate to the effect that a deceased had not married any woman other than the one named in the list should be insisted upon. Provisions of law regarding legal heirs, minors' interest and guardianship. Where the legal heir is a minor, lawful guardian will represent minor's interest. For Hindus and Christians, minor's father is the natural guardian, and after him the mother. Supreme Court has decided on guardianship to minor Hindu that even mother can be a natural guardian even during the lifetime of father, since the welfare of child is of utmost importance. For a Muslim minor, father then person appointed by father's will, then father's father, and then person appointed by father's father will be guardian in order. Provision of law regarding legal heirs. Legal heirs under various personal laws on Hindus. Primary heirs of a Hindu male, son, daughters, wife, mother, children of predeceased children, widow of predeceased son, children of predeceased grandchildren. Hindus. B. Primary heirs of Hindu female, sons, daughters, husband, children of predeceased children. Legal heirs under various personal laws. Muslims. Primary heirs of a Sunni Muslim. Sons, daughters, father, mother, spouse, husband or wife. Legal heirs under various personal laws. Muslims. Primary heirs of a Shia Muslim. Spouse, husband or wife. Mother, father, sons, daughters. Legal heirs under various personal laws. Christians. Primary heirs of a Christian. Spouse, husband or wife, sons, daughters. Legal heirs under various personal laws. Parsi. Primary heirs of a Parsi male. Wife, widow, sons, daughters, mother, father, children of predeceased children. Parsi. Primary heirs of a Parsi female. Husband, sons, daughters, children of predeceased children. Clarification on provisions in nomination rules. The Banking Companies Nomination Rules 1985 have been framed in terms of Section 45ZA to 45ZF of the Banking Regulation Act 1949. Deposit accounts. Nomination facility is intended only for individuals, including a sole proprietary concern. There cannot be more than one nominee in respect of single or joint deposit account. Banks may allow variation or cancellation of a subsisting nomination by all the surviving depositors acting together. This is also applicable to deposits having operating instructions either or survivor. In case of a joint deposit account, the nominee's right arises only after the death of all the depositors. Clarification for settlement in favor of non-resident depositors or claimants. In case the depositor is non-resident and has passed away abroad, the death certificate which is attested or certified by any of the following shall be accepted for processing the claim. Notary public in that country, Indian Embassy or High Commission in that country, bank's foreign office wherever it is possible or permissible to do attestation as per local regulations, Embassy or High Commission of that country in India. A death certificate accompanied by any of the following documents as a corroboratory evidence confirming incidents of death shall be accepted as such. Evidence of settlement of an insurance claim at foreign center on account of death of the account holder. Evidence of settlement of proceeds of bank accounts at foreign center on account of death of the account holder. Evidence of settlement of terminal benefits by the employer at foreign center on account of death of the account holder. However, the employer would have to be a government or multilateral organization only. Evidence of death as provided by a hospital or local police authorities at the foreign center. However, it may be ensured that any of these documents are issued from the same country as the death certificate. In case claimants, NRIs or foreign nationals stay abroad and it is not possible for them to come to India for completion of formalities, execute the documents abroad in the presence of officials of banks' foreign offices. Execute the documents in the presence of Indian embassy officials. The said document shall be submitted to the stamp authorities for payment of stamp duty after it reaches India. The claimant can appoint his attorney for obtaining proper legal representation and obtain payment against affidavit, indemnity, surety, etc. The procedure for the same is that the claimant should execute valid power of attorney (POA), which is attested by the Indian embassy officials. The assets of deceased NRI account holder should be settled to the legal heirs as per the personal law of succession, Hindu or Muslim, Christian or any other community applicable to the depositor. This is irrespective of whether the claimants happen to be a resident Indian, NRI, PIO or a foreign national. However, if any court order or legal representation is obtained, the process should be settled as ordered by court. In the case of a foreign court order, ancillary orders or resealing should be obtained from Indian court US 228 of the Indian Succession Act. Foreign nationals cannot be accepted as sureties while obtaining letter of indemnity as he or she will not be governed by Indian law. In case of legal representation, will probated by Indian court same as resident case. Will probated by foreign court properly authenticated copy of the will issued by foreign court is to be produced in the courts of India, who can then grant letters of administration, succession certificate or certificate of inheritance, letter of administration by Indian court, no additional due diligence except for KYC or proper identification of beneficiaries. In case of legal representation, succession certificate, certificate of inheritance, letter of administration by foreign court, issued by superior court of a reciprocating territory as notified by central government in official gazette, claimants to obtain a grant from competent state court in India for executing the certificate. In case where such certificate is not issued by superior court of reciprocating territory, claimant may be advised to file an application before appropriate district court in India for issuing a separate certificate afresh by producing the certificate issued by the foreign court. If succession certificate does not mention the bank account for which claim is being made, it will be treated as claim without legal representation and to be acted upon accordingly. Settlement of claims in various types of operational instructions. Deposit accounts with nomination. Account in the name of A. Operation instruction is safe. Nominee is X. Situation nominee dies. Account holder can change the nominee. Account in the name of A. Self operational instruction. Nominee is X. Account holder A dies. Nominee will receive the balance amount. Account in the name of A and B. Operational instruction is either or survivor. Nominee is X. Account holder A dies. Balance amount will be payable to account holder B. Account in the name of A and B. Operational instruction is either or survivor. Nominee is X. Account holder B dies. Balance amount will be payable to account holder A. Account in the name of A and B. Operational instruction is either survivor. Nominee is X. Account holder both A and B dies. Nominee will receive the balance amount. Account in the name of A and B. Operational instruction is jointly. Nominee is X. Account holder A dies. Balance amount will be payable to account holder B and legal heirs of A jointly. Account in the name of A and B. Operation instruction is jointly. Nominee is X. Account holder B dies. Balance amount will be payable to account holder A and legal heirs of B jointly. Account in the name of A and B. Operation instruction is jointly. Nominee is X. Account holder both A and B dies. Nominee will receive the balance amount. Without nomination. Account in the name of A. Operation instruction is sell. Account holder A dies. Balance amount will be payable to the legal heirs or any of them mandated by all the legal heirs of account holder A. Account in the name of A and B. Operation instruction either or survivor. Account holder A dies. Balance amount will be payable to account holder B. Account in the name of A and B. Operation instruction is either or survivor. Account holder B dies. Balance amount will be payable to account holder A. Account in the name of A and B. Operation instruction is either or survivor. Account holder both A and B dies. Balance amount will be jointly payable to legal heirs of account holder A and account holder B or any of them mandated by all the legal heirs. Account in the name of A and B. Operation instruction is jointly. Account holder A dies. Balance amount will be jointly payable to account holder B and legal heirs of A or any one of them mandated by all the legal heirs. Account in the name of A and B. Operation instruction is jointly. Account holder B dies. Balance amount jointly payable to account holder A and legal heirs of B or any one of them mandated by all the legal heirs. Account in the name of A and B. Operation instruction jointly. Both account holder A and B dies. Balance amount jointly payable to legal heirs of A and B or any of them mandated by all the legal heirs. Checklist of documents for settlement of claims in respect of deceased depositors. Accounts with nomination clause. Application for deceased claim settlement from nominee or guardian of nominee. Bank will provide the form. Copy of death certificate verified with original. Proof of certificate of nominee. Stamped receipt for amount received signed by nominee or person on behalf of minor nominee. Bank will provide the form. Original passbooks or unused checkbooks, etc. surrendered. Indemnity bond. Bank will provide form with stamp of requisite value. Joint accounts with either survivor or former survivor or anyone or survivor, letter or survivor clause as per mandate, a clause in account opening form for payment of balance to the survivors. Application for disease claim settlement form survivors. Bank will provide the form. Copy of death certificate verified with original. Proof of identification of survivor. Stamped receipt for amount received signed by survivors. Bank will provide the form. Original passbooks or unused checkbooks, etc. surrender. Indemnity bond. Bank will provide the form with a stamp of requisite value. For all other cases, including accounts without nomination or joint accounts with survivor clause for amounts up to threshold limit of rupees 40 lakhs, application for deceased claim settlement, bank will provide the form. Copy of death certificate, verified with original. Proof of authority of legal heirs, wherever applicable. Declaration from claimants for all claim amount up to rupees 5,000, bank will provide the form. Photograph and KYC of all claimants, legal heirs, person furnishing declaration or affidavit or sureties. Letter of disclaimer, bank will provide form wherever applicable. Affidavit, bank will provide form wherever applicable. Letter of indemnity, bank will provide the form wherever applicable. Opinion report on securities. Bank will provide form wherever applicable. Stamped receipt for amount received signed by all the legal heirs. Bank will provide the form. Original passbooks or unused checkbooks, etc. Surrendered or indemnity bond. Bank will provide form with stamp of requisite value. Settlement of claims based on legal representation by way of succession certificate, letter of administration, probate, etc. Application for deceased claim settlement. Bank will provide form. Proof of death verified from original. Photograph and KYC of all claimants, legal heirs eligible for deceased claims based on the legal representation. Legal representation, succession certificate, letter of administration, probate, etc. Original passbooks or unused checkbooks, etc. Surrendered or indemnity bond, bank will provide form with stamp of requisite value. Settlement of claims in respect of missing persons. Legal position. The settlement of claims in respect of missing persons is governed by the provisions of Section 107 by 108 of the Indian Evidence Act 1872. Section 107 deals with presumption of continuance and Section 108 deals with presumption of death of a missing person. As per the provision of Section 108 of the Indian Evidence Act 1872, presumption of death can be raised only after a lapse of 7 years from the date of person being reported missing. The nominee or legal heirs of the missing person have to raise an express presumption of the depositor or subscriber under Section 107 by 108 of the Indian Evidence Act 1872 before a competent court or civil court. If the court presumes that the missing person is dead, it issues an order for settlement of the claim in respect of the missing person, depositor, and accordingly the claims are to be settled by the bank. Simplification of the process for settlement of claims in missing depositors' accounts. Documents. Documentation. The documents required to be obtained from the nominee or legal heirs or claimants along with application form for settlement of dues in respect of missing persons are as under. Copy of FIR or if the same is not available, the copy of missing persons report duly issued by the concerned police station. Certificate issued by the police authorities that such missing person is not traceable. The certificate report of non-traceability of missing persons by the police authorities should be of a date after 7 years from the date of the persons has gone missing as recorded in the registration of FIR or missing persons report duly issued by the concerned police station and the inquiry by the police authority. Declaration by the nominee or legal heirs of that missing person depositor that the nominee person has not been heard of for the last 7 years. Certified copy of orders from the competent court presuming missing person as deceased or death certificate issued from competent authority wherever applicable. Proof of identification of nominee, legal heirs, shelters as applicable. Letter of disclaimer duly stamped and notarized. Bank will provide form wherever applicable. Affidavit duly stamped and notarized. Bank will provide form wherever applicable. Indemnity letter. Bank will provide form wherever applicable. Opinion report of securities along with documented evidence. Bank will provide the form wherever applicable. Probated will or succession certificate, letter of administration issued by competent jurisdiction wherever applicable. Confirmation about legal heirs in case of settlement of claim to the legal heirs based on indemnity with securities. Settlement of claims in respect of missing persons. All guidelines, delegations, time norms, and due diligence at the time of settlement of claims, documents required like declaration, affidavit, opinion report of securities, etc., without production of legal representation up to rupees 40 lakhs in respect of deceased depositors would also applicable in cases of claims of a missing account holder. In the cases of claim up to rupees 1 lakh, claim can be settled on application being made by the legal heirs or nominee or executor or administrator. The basis copy of FIR, police report of non-traceability issued on a date after 7 years from date of registration of FIR with indemnity letter and sureties. In cases of claim amount above rupees 1 lakh and up to rupees 40 lakhs, the nominee or legal heirs of the missing person maintaining deposit accounts are required to submit certificate copy of order from the competent court presuming missing person as deceased under section 107 by 108 of the Indian Evidence Act 1872 or death certificate issued from competent authority issued on a date after 7 years from the registration of FIR and indemnity and surety as stated above. In cases of natural calamities like Uttarakhand disaster 2013 and death certificate issued prior to the date of 7 years from the occurrence of natural calamity in accordance with the guidelines notified by the Ministry of Home Affairs, central government can be accepted for settlement of missing persons claims without the separate court orders on declaring missing person as deceased or non-traceability report by the police of a date after 7 years from the date of registration of FIR. Settlement of claims above the threshold limit of rupees 40 lakhs are to be settled on basis of legal representation, that is succession certificate, letter of administration, probate, etc. and also order from the competent court presuming missing person as deceased under section 107 by 108 of the Indian Evidence Act 1872 or death certificate issued from competent authority issued on a date after 7 years from the registration of FIR. In case there exists a valid nomination, then the nominee while requesting to release the amount has to submit certified copy of orders from the competent court presuming missing person as deceased under section 107 by 108 of the Indian Evidence Act 1972. In case where there is dispute between the legal heirs or claimants, even if the claim amount is within the threshold limit of rupees 40 lakhs, branches should insist for necessary court order by way of succession certificate or letter of administration, probate, etc. for settlement of claim. Branches should obtain applicable application from and requisite documents as per checklist while settling claim pertaining to a missing person maintaining deposit accounts. Branches should obtain an indemnity letter duly executed by all the legal heirs and the sureties of appropriate oath, along with the receipt of full and final settlement of claim. If such claim is settled on the basis of indemnity and claim amount is up to threshold limit of rupees 40 lakhs. Procedure for registration of death of missing person in natural calamities affected areas in Uttarakhand. The Interministerial Group IMG on Uttarakhand, headed by the Cabinet Secretary in its meeting held on 2nd August 2013, requested the Registrar General and Census Commissioner India to formulate a standard procedure for issuing death certificate after due inquiry in case of the missing persons of Uttarakhand and other states. Accordingly, the following procedure was communicated for necessary action by the concerned chief registrars of births and deaths. As per the provision of Section 7 by 2 of the Registration of Births and Deaths Act 1969, the registration of birth and death has to take place at the place of occurrence of the event. In normal circumstances, the death is registered only on the reports from persons mentioned in Section 8 of the RBD Act 1969. However, in extraordinary cases like the one in Uttarakhand, reports from public servants after due inquiry can be made use of for registering the deaths. Procedure for registering of deaths of missing persons in natural calamities affected areas in Uttarakhand. As regards person whose dead body has been found, it is needless to state that the normal process of issuing death certificates should be followed. In case of missing persons who in all likelihood have died but the dead body is not traceable, all reasonable efforts should be made to determine that the person has in all likelihood died in the natural calamity that occurred in Uttarakhand. The following process of inquiry and categorization of missing persons are to be done. Permanent residents of the flood affected villages and permanent residents of the nearby villages of Uttarakhand who were present in the flood affected villages during the catastrophe. Residents of other districts of Uttarakhand who were present in the flood affected villages during the catastrophe. Tourists from other states who were present in the flood affected villages during the catastrophe. Process to be followed in the case of permanent residents of the flood affected villages and permanent residents of the nearby villages of Uttarakhand who were present in the flood affected villages during the catastrophe. A FIR or missing persons report should be filed by the close relatives or next of kin at the place of residence of the person who is missing and presumed dead. The FIR or missing person report should be referred to the concerned police station under whose jurisdiction the person went missing. Notarized affidavit regarding missing should be filed by next of kin and should be kept as a permanent record. The FIR or missing persons report should then be forwarded to the designated officer, Pargana Adhikari or SDM of the concerned area in Uttarakhand along with report of police station and supporting documents for identification like ration card, family register, bank passbook, etc. The designated officer should conduct a detailed inquiry regarding the missing person. Based on the inquiry as detailed above, the designated officer of Uttarakhand should issue a speaking order regarding the provisional presumption of death. The designated officer should then cause publication of the list of missing persons provisionally presumed dead in the newspaper, government gazette in Hindi and English, and also host the same on the government website for the purpose of obtaining claims and objections. Claims and objections should be received within 30 days. If no claim or objection is received within the time period, the designated officer should issue the death certificate. The death certificate should be made available free of cost to the next of kin. The death certificate should also be sent to the police station where the FIR or missing persons report was filed. In case of claims and objections, an appeal would lie with the officer immediately superior to the designated officer to be nominated by the state government. After dealing with the appeal, the speaking orders should be sent to the designated officer who would then take appropriate action to issue the death certificate or deny it. Process to be followed in case of residents of other districts of Uttarakhand who were present in the flood affected villages during the catastrophe. FIR or missing persons reports should be filed by close relatives or next of kin at the place of residence in the originating district. If FIR or missing persons report has already been filed in calamity affected areas of Uttarakhand, the designated officer should forward the same to the designated officer or SHO of the police station at the place of usual residence in the district of origin of the missing person for local inquiry at their end. Notarized affidavit regarding missing to be filed by next of kin and to be kept as a permanent record. The inquiry officer in the originating district should conduct inquiry to establish the following facts: that the family members of the relatives or friends of the person concerned had filed FIR or missing person report well in time before 30th June 2013. If it is beyond this time limit, the reasons for approaching the police late should be inquired. That the person concerned had travelled to the affected areas of Uttarakhand before 16th June 2013. That the person has been missing after his departure for affected district. The inquiry report should be sent to the concerned designated officer at the affected areas of Uttarakhand. Based on the inquiry report of the officer in the originating district, the designated officer in affected areas of Uttarakhand should further inquire into the fact of disappearance of the persons concerned by looking into the database of missing persons maintained by the missing persons cell at Dehradun by the state government. He should also take into account all available information, including the statements of witnesses, if any, and last call data and other relevant data from mobile phone service providers to arrive at a conclusion regarding the death of the person. All available evidences may be taken into consideration before concluding whether the person has died or not. This may include police reports, inquiries from relief camps, and affidavits submitted by the close relatives or next of kin, etc. Based on the inquiry as detailed above, the designated officer of affected areas may issue a speaking order regarding the provisional presumption of death. This order should be communicated to the designated officer in the originating district. On receipt of such order, the designated officer in the originating district should cause publication of the list of missing persons presumed dead in the newspaper, government gazette in Hindi and English, and also host the same on the government website for the purpose of claims and objections. Claims and objections may be received within 30 days. If no claim or objection is received within the time period, the designated officer in the originating district should send a report to the designated officer in affected areas of Uttarakhand. Based on this report, the designated officer in affected areas of Uttarakhand should issue the death certificate. The death certificate should be made available free of cost to the next of kin. The death certificate should also be sent to the police station where the FIR missing person report was filed and to the designated officer in the originating district. Processes to be followed in case of residents of other districts of Uttarakhand who were present in the flood affected villages during the catastrophe. In cases of claims and objections, an appeal would lie with the officer immediately superior to the designated officer to be nominated by the state government. After dealing with the appeal, speaking orders should be sent to the designated officer in affected areas of Uttarakhand, who would then take appropriate action to issue the death certificate or deny it. Process to be followed in case of tourists from other states who were present in the flood affected villages during the catastrophe. FIR or missing persons report to be filed by close relatives or next of kin at the place of residence in the originating state. If FIR or missing person report have already been filed in Uttarakhand, the designated officer of Uttarakhand should forward the same to the designated officer or SHO of the police station at the place of usual residence in the state of origin of the missing person for local inquiry at their end. Notarized affidavit regarding missing to be filed by next of kin and to be kept as a permanent record. The inquiring officer in the originating state should conduct inquiry to establish the following facts: that the family members or relatives or friends of the person concerned had filed FIR or missing persons report well in time before 30th June 2013. If it is beyond this time limit, the reasons for approaching the police late should be inquired. That the person concerned had travelled to Uttarakhand before 16th June 2013. That the person has been missing after his departure for Uttarakhand. For arriving at its conclusion, the inquiry officer should also verify with reference to the database maintained for this purpose by the resident commissioner of the originating state government at New Delhi or the authorized officer of the state government who had camped at Dehradun during June 2013 to conduct inquiry on missing persons from their states. The inquiry report should be sent to the concerned designated officer at Uttarakhand. Based on the inquiry report of the officer in the originating state, the designated officer in the Uttarakhand should further inquiry into the fact of disappearance of the persons concerned by looking into the database of missing persons maintained by the missing persons cell at Dehradun by the state government. This should also take into account all available information, including the statements of witness, if any, and last call data and other relevant data from mobile phone service providers to arrive at a conclusion regarding the death of the person. All available evidences may be taken into consideration before concluding whether the person has died or not. This may include police reports, inquiries from relief camps, and affidavits submitted by the close relatives and next of kin, etc. Based on the inquiry as detailed above, the designated officer of Uttarakhand may issue a speaking order regarding the provisional resumption of death. This order should be communicated to the designated officer in the originating state. On receipt of such order, the designated officer in that originating state should cause publication of the list of missing persons presumed dead in the newspaper, government gazette in the local language of the state and English, and also host the same on the government website for the purpose of claims and objections. Claims and objections may be received within 30 days. If no claim or objection is received within the time period, the designated officer in the originating state should send a report to the designated officer in Uttarakhand. Based on this report, the designated officer in Uttarakhand should issue the death certificate. The death certificate should be made available free of cost to the next of kin. The death certificate should also be sent to the police station where the FIR or missing persons report was filed and to the designated officer in the originating state. In case of claims and objections, an appeal would lie with the officer immediately superior to the designated officer to be nominated by the originating state government. After dealing with the appeal, speaking of orders should be sent to the designated officer in Uttarakhand, who would then take appropriate action to issue the death certificate or deny it. Procedure for registration of death of missing persons in natural calamities affected areas in Uttarakhand. For enabling this process, the designated officer, Pargana Adhikari or SDM in Uttarakhand may be declared as a registered of death under Section 7 by 1 of the Registration of Births and Deaths RBT Act 1969. In all the above cases, registration of death may be done at the place of occurrence of death or presumed death in accordance with provisions made under Section 7 by 2 of RBT Act. Checklist of documents of settlement of claims in respect of missing depositors. Accounts with nomination closure. Application for settlement of claim in missing depositors accounts from nominee bank will provide form. Court order issued by an honorable judge declaring missing person as deceased. Death certificate issued by competent authority wherever applicable. Proof of identification of nominee such as passport, driving license, proof of possession of Aadhaar number, the voter's identity card issued by the Election Commission of India, job card issued by NREJ duly signed by an officer of the state government, letter issued by the National Population Register containing details of the name and address, etc. Copy of FIR lodged with police authority, certificate issued by police authority that such missing person is not traceable. The report of non-traceability of missing person by the police should be of a death after 7 years from the date of registration of FIR and inquiry by the police authority, declaration by the nominee of that missing person or depositor that the missing person has not been heard of for that the last 7 years, stamped receipt or declaration in case of funds are settled in favor of a minor, bank will provide form. Joint accounts with either a survivor or former or survivor or anyone or survivor or later or survivor clause as per mandate or clause in account opening form for repayment of balances to survivors. Application for settlement of claim in missing depositors accounts from nominee bank will provide form. Court order issued by honorable judge declaring missing person as declared or death certificate issued by competent authority wherever applicable. Copy of FIR lodged with police authority. Certificate issued by police authorities that such missing person is not traceable. The report of non-traceability of missing person by the police should be of a date after 7 years from the date of registration of FIR and inquiry by the police authority. Declaration by the survivor of the missing person or depositors that the missing person has not been heard of for the last 7 years. Stamped receipt or declaration in case funds are settled in favor of a minor, bank will provide for. For all other cases, including accounts without nomination or joint accounts with survivor clause for amounts up to threshold limit of rupees 40 lakh. Application for settlement of claim in missing depositors accounts from nominee, bank will provide for. Court order issued by honorable judge declaring missing person as deceased. Death certificate issued by competent authority or wherever applicable. Proof of identification of all claimants such as passport, driving license, proof of possession of Aadhaar number, the voter's identity card issued by the Election Commission of India, job card issued by NREGA duly signed by an officer of state government, letter issued by the National Population Register containing details of name and address, etc. Copy of FIR lodged with police authority, certificate issued by police authorities that such missing person is not traceable. The report of non-traceability of missing person by the police should be of a date after 7 years from the date of registration of FIR and inquiry by the police authority. Declaration by the legal heirs of the missing person and depositors that the missing person has not been heard of for the last 7 years. Letter of disclaimer, bank will provide form wherever applicable. Affidavit, bank will provide form wherever applicable. Letter of indemnity, bank will provide form wherever applicable. Opinion report on securities, bank will provide form wherever applicable. Stamped receipt or declaration in case funds are settled in favor of minor, bank will provide form. Settlement of claims in missing depositors accounts based on the legal representations by way of succession certificate, letter of administration, probate, etc. Application for settlement of claim in missing depositors accounts from nominee, bank will provide form. Legal representation, succession certificate or letter of administration or probate, etc. Court orders issued by honorable judge declaring missing person as deceased and death certificate issued by competent authority wherever applicable. If it is mentioned in succession certificate or letter of administration, no separate court order required. Proof of identification of all claimants such as passport, driving license, proof of possession of Aadhaar number, the voter's identity card issued by the Election Commission of India, job card issued by NREGA duly signed by an officer of the state government, letter issued by the National Population Register containing details of name and address, etc. based on the legal representation. Stamped receipt, declaration in case funds are settled in favor of a minor, bank will provide for. Settlement of claims in respect of missing persons with nomination. Savings or current account. Single depositor nominee is available. Joint account operated jointly on missing of one depositor, legal heirs of missing depositor plus survivors. Missing of all depositors nominee. Joint account either survivor or missing of one depositor survivor on missing of both the depositors nominee. Joint account former survivor on missing of former survivor on missing of both the depositors nominee. Joint account any owner survivors on missing of one or more survivors on missing of all the depositors nominee. With nomination, nature of account, term deposit accounts on maturity, same as savings or current account. Premature withdrawal of term deposit, same as savings and current account. For single depositor, joint account operated jointly, joint account either survivor, joint account former survivor, joint account any owner survivor. Without nomination, nature of account, savings or current account. Single depositor, legal heirs of persons mandated by them. Joint account operated jointly on missing of one depositor, legal heirs of missing depositors plus survivors. On missing of all depositors, legal heirs of all the depositors. Joint account, either or survivor. On missing of one depositor, survivor. On missing of both the depositors, legal heirs of all the depositors. Joint account, former or survivor. On missing of former, survivor. On missing of both the depositors, legal heirs of all the depositors. Joint account, any owner survivors. On missing of one or more depositors, survivors. On missing of all the depositors, legal heirs of all the depositors. For term deposit accounts, on maturity and premature withdrawal of term deposit account. Same as per savings or current account. For single depositors, joint account, jointly, joint account either a survivor, joint account former or survivor, joint account any owner survivor. Same procedure as per savings and current account. Terms of contract for premature withdrawal of term deposit accounts in missing persons. The terms and conditions agreed between the bank and depositors, all the depositors in case of joint accounts in account opening form or subsequent changes accepted by the bank on the joint request or mandate of all the depositors during the tenure of accounts on, especially on rate of interest to be payable, operational instruction on premature withdrawal, permitting premature withdrawal, etc. Guidelines on operational instructions on premature termination of term deposit accounts in joint account with mandate either survivor or former survivor or any owner survivor or later or survivor with or without nomination are further clarified as under. In the event of the missing of one or more but not all of the depositors, the balance amount can be paid to the survivors by premature termination of term deposit accounts on verification of requisite documents submitted for proof of declaring missing persons as deceased. Only if there is a joint mandate from all the depositors to this effect, given either at the time of placing the fixed deposit or subsequently during the tenure of deposit, or the clause in this regard in the deposit account opening form is accepted and signed by all the depositors at the time of opening of fixed deposit account. In the event of the missing of one or more but not all of the depositors, payment before maturity cannot be made to survivors only without having joint mandate from all the depositors or suitable clause in the account opening form to this effect as stated in clause above. In such cases, the balance amount will be paid jointly to survivors and the legal heirs of the missing joint account holders, or any of them as mandated by all the legal heirs, against their joint claim on verification of authority of the legal heirs and verification of requisite uh, document from proof of declaring missing persons as deceased. With nomination. In the event of missing of all the joint depositors, the nominee will have right to seek premature termination of term deposit account as per the terms of the contract on verification of claimant's identity such as PAN card, election ID card, Aadhaar card, Manrega card, passport, driving license, etc. and verification of requisite documents submitted for proof of declaring missing persons as deceased of all the depositors. Thank you very much for your patience.